and good morning to our cherished viewers and listeners.
I hope you're well.
By the grace of Malgan Sobolisa, I'm doing well.
Have you read? No, I think that question is moot. I know you have read it. What are your comments on the judgment, the Supreme Court judgment, now that is out, as in North, the Gyakye Quayson matter?
Okay. You see, for me, even before the Supreme Court judgment, I had a fair idea of how the judgment would look like. And from what was released to the public, the certified copy, I have no doubt at all that whatever it is that I anticipated was confirmed in the judgment. Right? Was confirmed in the judgment.
Oh, okay.
Oh, yes. You see, immediately the Supreme Court granted the injunction. Right? I knew that this would be the end game. You see, from 1992 to date, there had been series of parliamentary election challenge. Correct?
Yes.
Good. Now, of all these parliamentary election challenge, there has never been an injunction granted against anybody. And you see, the precedent that the Supreme Court has set effectively means that even in the presidential election petition, the Supreme Court may want to injunct the president from working simply because there's a petition against it. Do you get the point? Hello, Sana?
Yes.
Because you see, for almost a year, that the petition or the Supreme Court injuncted Gyakye Quayson, there was no representation for the people of Asino, correct? What is the essence of creating that lacuna? Who did it benefit? The people of Asino or that one petitioner? We all know that the injunction is a discretionary remedy, correct? And so usually, at the tail end, what you do is that you balance the interests. Injunction is not given as of right, it's discretionary. And so we know that the basic tenet is that you must always demonstrate to the satisfaction of the court that your interest as a petitioner is greater than the interest of the whole people of Asino who needs representation. But you see, I am not surprised because you see, in this country, we can wake up one morning and the Electoral Commission with an administrative fiat can say the people in Lolobi, Central Kopi, Akwafu, Likwe, you can't vote. And we've all gone to sleep. An electoral commissioner, with just pen and paper, decided that over 10,000 people, registered voters in a particular area, should not be permitted to vote in parliamentary elections. And nothing had happened. So some of the things that happen in this republic, it doesn't surprise me personally. You see, if you pick the Supreme Court judgment, it's 35 pages. Hello, Tana?
Yes.
It's 35 pages.
Yeah.
Now, if you pick that 35-page judgment, you'll notice that close to 19 pages of the whole judgment was about, what do we call it? Was simply about rehashing the arguments of the parties.
Yeah.
About 19 pages. If you read, it set out the facts It proceeds to say the argument of the plaintiff. Then it goes out to say the argument of the petitioner, now plaintiff, the argument of the first defendant, second defendant, third defendant. Then now they started the evaluation of their own reasoning and analysis. But you see, one thing is strikingly unique in the judgment. What is this? The Supreme Court says that you, Gyakye Quayson, if you had gotten your certificate of renunciation, say in October or October 1st, 2020, we won't have a problem with you. If you have gotten your, what shall I say, your certificate of renunciation, even on October 8th, we won't have a problem with you. Simply because you in fact got your certificate of renunciation on the 9th, on 26th of November 2020, even before your election, will annul your election. I mean, Senna, you wonder, what's the end of justice? Senna, what is the end of justice? Because I strongly believe that this is a court of law and a court of justice, correct?
Yeah.
So what exactly is this judgment seeking to achieve? See, Article 94, 2A. What is in it? It says that a person shall not be qualified to contest as a member of parliament. As a member of parliament, if he owes allegiance to a country other than Ghana, correct? So now, in the constitutional provision, did the framers of the Constitution say, if he is a citizen of another country? So now,
no, they're talking about allegiance.
Allegiance. So what we should all be concerned about is the word owes allegiance appearing in Article 94.2a. What does it mean? Should that not satisfy the provision? Because you see, any interpretation of Article 94.2a that does not put the word allegiance in context will be creating a problem. We'll be creating a problem, Senna. We'll be creating a problem. Because you see, if in the wisdom of the framers of the 1992 Constitution, they intended that Article 94.2a should read, owes a citizenship of another country other than Ghana, don't you think they would have said so? Now, there had been a certain reliance on the Zanato case.
Before you get there, I just wanted to draw attention on the matter of allegiance. The Supreme Court draws an analogy with the kind of oath you take, for example, to become a British citizen. When they say you swear allegiance to the king or queen, their heirs, and the United Kingdom. So to them, in essence, that oath confers allegiance on you. So unless they give you, in this case, a certificate that says that he is no longer owes allegiance or has.
No. You see, excuse my language. That's a very excuse my language, simplistic approach, you notice that allegiance is a voluntary act. Citizenship, for instance, if your parents are Ghanaian, you don't become a Ghanaian voluntarily, correct? Did you become Ghanaian voluntarily?
No. I was born.
You were born. But where you are now, you can voluntarily decide that today I owe allegiance to another country, correct?
Yeah.
But as for your birth, it is natural. I mean, it's by birth. It came together with you. It is your make, unless they drain your blood out of you. So you notice that citizenship is a bigger conversation than allegiance. You see, the reference has been made to the Zenato decision. And that even further exposes a lot of issues. You see, when Zenato was decided, hello?
Yes. In fact, I said to it, yeah.
Yes. As you recall, I argued Zenato. And when I argued Zenato, what were the arguments put in the Zenato matter? Zenato was decided on this score. First, there was an NDC primaries, correct? Zenato had won. And when she won, there was an intervention at the High Court that, listen carefully, that within the meaning of Article 94, 1A, which deals with the fact that a person desiring to contest must be a registered voter. She was not qualified, a registered voter. So we then make the argument that the time when we can start a conversation as to qualification should not be at the party primaries, right? But the conversations to start when the EC has open nomination, so that whether or not the person is qualified or not, that conversation be had right from the time when the EC opens nomination. As to where the conversation ends, the Supreme Court didn't deal with it.
Okay.
Yes.
So, because you were saying the matter arises, and I recall that was a specific phrasing, that it will only arise when the EC opens nominations.
That's all.
But I didn't say that is
what
the...
is the limit?
Yeah.
Sena,
Okay.
that was it. Nothing more. So let me tell you something. You see, the Supreme Court, when his name filed a petition against Gyakye Quayson at the High Court, we went to the High Court. My law firm started the defense of Gyakye Quayson. In fact, we prepared his initial answers to the petition. And then we drew the attention of the High Court judge. So now listen carefully. We drew the attention of the High Court judge. And my Lord, as far as Article 94(2)A is concerned, meant by the Apex Court. So, in order to do justice, because we are saying that the operative word in Article 94(2)A is allegiance, not citizenship. Because you see, that chapter never interchanged the word citizenship for allegiance, not even once. So that, for instance, There's no instance where the charter says, you being a citizen of Ghana, it can be acquired by birth, so that allegiance can be acquired by birth, naturalization or something. Or you obtain your allegiance to a country through your grandparents. But it says that you can obtain your citizenship of Ghana if you have one grandparent who is a Ghanaian. So the framers of the Constitution were very clear in the text, so that if they had meant to interpret, so we then put this position to the judge and said, look, we, as far as 2019, when I say we, I mean Gyakye Quayson, he had taken steps to disavow his allegiance. So at the barest minimum, like a customary marriage, when you are going, you go with drinks, courage. The day you say, I'm okay, and the drinks back. So you disavow. You've washed your hands off. So we made this argument and said, look, 94.2a is unique. So, my Lord High Court Judge, by reason of Article 132, it says that where in the course of a proceeding, an issue of interpretation arises, say your proceedings and refer the matter to the Supreme Court. Is that not what the provision says?
Yes, I recall. I recall that was what happened in the Zanato matter too.
Fantastic. So we then told the judge that this is what you should be doing. Then Frank Davis, who is the lawyer for the petitioner, I want you to mark these events down. So Mr. Frank Davis stood up on his feet and said, oh my Lord, I object to this application for referral to the Supreme Court, because Article 94.2a is clear, unambiguous, and does not require any interpretation. So now, have you put it down?
Yeah.
This was at the High Court. Now, Gyakye Quayson, after the High Court judge granted the injunction and subsequently decided the petition against him, Gyakye Quayson now goes to the Supreme Court to say, Supreme Court, to the extent that this High Court judge says that he, as a High Court judge, can deal with Article 94 because it's clear and unambiguous, he has exceeded his jurisdiction, because Article 132 is clear. It says shall. It didn't say may. It says shall. And they are territorial of decisions from the Supreme Court, even Senator itself. So when we make this argument, Gyakye Quayson went to the Supreme Court. Then the Supreme Court said, listen carefully, that what the High Court judge did was clear. The High Court judge has not offended any of the laws of this country. And so the judgment of the High Court judge is proper on the referral. If you compare to Zanato, the High Court judge had also made a similar pronouncement. But the Supreme Court said he was in error. And that is why the Supreme Court quashed the two rulings of the High Court judge. You recall?
Yeah.
Good. So, High Court judge, the Supreme Court said, oh, the provision is clear, he could have dealt with it. The Supreme Court do. Then, Gyakye Quayson now files his appeal. And in the grounds of appeal, raise all these constitutional matters. Now, when you raise these constitutional matters as error of law, we applied, led by Senior Church Secretary, we applied to the Court of Appeal. That time, the Court of Appeal was sitting in Cape Coast. We applied to the Court of Appeal in Cape Coast and said, listen, we beg you, 132 proceedings, and refer the matter to the Supreme Court. Yet again, the Court of Appeal refused the application for referral. And that application was opposed by Mr. Frank Davis. The Court of Appeal agreed that there was no need for the referral because the constitutional provision is clear and unambiguous. Are you okay? Then we said, okay. So after the Court of Appeal ruling that there was no need for referral, we then approached the Supreme Court and said, Supreme Court, this is what the Court of Appeal is saying in Cape Coast, contrary to the dictates of Article 132. So, quash the refusal to refer and refer Article 132 to yourselves. Are you following the tragedy?
Yes.
Good. Now, at the Supreme, three of the Supreme Court judges, including Justice Tokono, now CJ nominee, said what the High Court, the Court of Appeal did in Cape Coast is correct, and that there is no need to refer Article 132 to the Supreme Court. Davis came and opposed the Sisirara application, saying that the Court of Appeal has not offended Article 132 because the constitutional provision is clear and unambiguous and therefore requires no interpretation. Three of the Supreme Court judges actually agreed with that position. Whatever it is that the Court of Appeal has said is the correct position of the law. Three of the Supreme Court judges. So now we thought that the Supreme Court, having by a 3-2 majority indicated that the constitutional provision is clear and unambiguous and requires no interpretation, it has brought finality to the question of interpretation. Correct?
Yes.
Correct.
Yes, that should be it.
Good. Now, from nowhere, the same lawyer, the same petitioner, who has consistently opposed any application for referral. So now guess what? Now issues a writ at the Supreme Court asking for interpretation of the same provision. So now, can you imagine?
The same person who has been opposing and making the point that the law is clear enough.
Look, on 4 different occasions, said the law is clear enough. The law requires no further interpretation. Miraculously, now issues a writ at the Supreme Court. So now, what do you make of this?
And the Supreme Court that has been agreeing with him on the other point agrees with him.
The first panel was presided over by Justice Yawa Pao. The second panel had Justice Tokonu and Go in it. On 2 different occasions, Gyakye Quayson went to the Supreme Court for Sisirara. And on those 2 occasions, the Supreme Court said the provision is clear and unambiguous. Does this not strike you all? Now, guess what? When the Supreme Court, now even before then, let me tell you another thing. You see, Amewu's case. You remember the Amewu case?
Yeah.
Good. You see, a High Court judge had granted an injunction against Amewu. You remember?
Yes.
Then Amewu AG and Co brought an application for certiorari, saying that the originating process that resulted in that injunction was a human rights application. And so any dispute involving parliamentary election challenge should come by way of a petition. Do you know that my lady Gyakye Quayson was on that panel? Do you know what she said? She said, look, it doesn't matter how the process is closed. Once the process involves ultimately the challenge of a person's parliamentary election, the originating process must be a petition to the High Court. It doesn't matter how you put it, whether in substance or form. What is important is that you are challenging the election, the eligibility, the qualification of a person to be a member of parliament, and that the starting point should be the High Court. This was the Supreme Court. Suddenly, a writ is issued at the Supreme Court, which in substance and form is challenging the election of Gyakye Quayson. Correct?
Yes.
And the Supreme Court said, no, this is a proper action for our original jurisdiction.
And I thought, as you always say, they can depart from their rulings. Is that not the terminology you use? Depart.
You see, anytime the Supreme Court wants to depart from its ruling, the Constitution requires that it must justify the departure. It is not something that is done just because of anything. No. The Supreme Court itself says that any time that the court is minded, right, to depart from its previous decision, it must provide justification for that departure. Where was that justification? In the instant case of Gyakye Quayson. So you see, so for some of us who have followed this Gyakye Quayson matter, a few things strike us very oddly. Shana, a few things strike us extremely odd. Supreme Court, Gyakye Quayson had approached you on 2 different occasions. And on these 2 different occasions, Supreme Court, you have always told him that there was no basis for the referral to you, and that the courts below have the jurisdiction to deal with the matter clearly. Shana, I beg your pardon. How did it happen that in the instant case of Gyakye Quayson, immediately when... Hello?
Yes, I'm listening to you.
Immediately when the same petitioner with a lawyer who have consistently refused the application for referral to the Supreme Court now issues a writ for interpretation before the Supreme Court, and the Supreme Court now says, no, we agree with you. So, look, I wish I would have the benefit of asking, my Lord, is it the case that you do not have the benefit of the records of proceedings that have been put before you earlier?
So this is quite baffling.
You see, for me, it is beyond baffling. It is not like even the plaintiff has changed. So, for instance, at the High Court, it is fact. Now, at the Supreme Court, it is Sena Numbo.
Okay.
And the lawyer is my brother in the studio, Obwache. The same lawyer at the High Court, Court of Appeal, the same petitioner at the High Court, Court of Appeal, now turns himself into a plaintiff, not a petitioner again, with the same lawyer who has consistently opposed the application for referral. You know, these days, some of us who are learning the law, it keeps us, as it were, wondering. It puts certain mental stress on us.
Okay.
We keep wondering, so what happened? How so different is Gyakye Quayson's matter? What is the unique thing about the issue involving Gyakye Quayson that the man himself went to the Supreme Court twice and said, Supreme Court judges, I am on my knees. I am begging you. Article 94(2)(a) is unique. The High Court judge has usurped the power to interpret it. The Constitution is says in Article 132 that in the course of any proceeding, if an issue of interpretation arises, please do refer to us. It didn't say may, it says shall. Say proceeding and refer to the Supreme Court. So that the Supreme Court will exercise its original jurisdiction relative to interpretation. So now,
well, lawyer, we have to bring this to a close. But before we do that, I just wanted, for the sake of emphasis, when you went before in the Senator matter, you said, well, this matter can only come up when nominations open. The EC has not opened nominations.
So,
now, the Supreme Court's decision then means now that the matter will come up and is concluded the day when the person files.
There's something I even want to draw your attention so that you see that this thing that I've said, it is not like Edudzi who is just saying it for the sake of maybe political communication or something. You know, I told you that after the High Court judge, the Court of Appeal had refused. Hello?
Yes, I'm listening to you.
After the High Court judge had refused the issue, the Court of Appeal had refused the issue of the referral.
Yeah.
You know, I told you that Gyakye Quayson went to the Supreme Court to quash the refusal by the Court of Appeal.
Yes.
At the Supreme Court, it was 3-2. Justice Foreman and I think Edudzi, they dissented. And do you know what Justice Foreman said? Do you know what he said?
No.
Good. He said, he has seen reliance placed on the senator decision by the petitioner and even the Court of Appeal. But he was on the senator panel. None of his colleagues was on the senator panel.
Yeah.
And that when they considered senator's decision, they didn't consider Article 94(2)(a).
Okay.
Yes. So, he said, look, when they considered the senator decision, the constitutional provision that they dealt with was not Article 94(2)(a). So for the Court of Appeal and the High Court judge to say Article 94 is clear and unambiguous, that's even error on the law, error of law on the face of the record.
That is from one of the judges who subscribed.
Okay. Gyakye went to the Supreme Court.
But he subscribed to the decision given in Senator. So he was part of that case, I recall vividly.
He said he was a member of the panel.
Yes, he was on that panel.
Yes, and so he, when they considered the Senator decision, did not consider Article 94(2)(a). So for anybody to say that because of Senator, Article 94(2)(a) has been properly interpreted and therefore there was no need for referral to the, what shall I say, to
the Supreme Court.
To the Supreme Court. That in itself is error of law on the face of the record. Look, there's something I just want to read something. The judgment. Okay? Pardon me, I beg you. There's something that the High Court judge said. I just want to read that portion to you.
Okay. I'm listening.
Please bear me out briefly. Because the issue of referring 94. Now listen to the High Court judge. He said, quote, the above dicta, as the court always understand it, means that there is no case of enforcement or interpretation where the language of the article is clear, precise, unambiguous, and reasonably where the Supreme Court has already interpreted the provision. In such an eventuality, the aggrieved person may appeal in the usual way to the higher court against what he may consider to be erroneous construction of those words. And he should certainly not invoke the Supreme Court's original jurisdiction. Did you hear what the High Court just said?
Yes.
Are you listening?
Yes, I'm listening.
Then he goes on. Again, where the submission made relates to no more than the proper application of the provision of the Constitution to the fact in issue. This is a matter for the trial court to deal with, and no case for interpretation arises. On the strength of the above delivery, it does appear to the court that the meaning and effect of Article 94(2)(a) of the Constitution are devoid of any ambiguity to warrant a referral.
Okay.
Are you okay?
Yes.
Now he proceeds. The above constitutional provision has given birth to a statutory reenactment in Section 92 of PNGC Law 284 Supra. Now, listen to what he says. Equally, Article 94(2) of the Constitution has received judicial consideration and clarity by the Supreme Court, which is by law the highest court of the land, and he refers the case of ex parte senator. Boss, Senna, have you seen what has happened? So, even at the High Court, you heard what the High Court has said. So now that the Supreme Court decided to assume jurisdiction, when the same plaintiff, then petitioner, had now approached to them, was the High Court judge therefore in error? Senna. So you see what has happened?
Okay. Laura, we have to leave it here. I think there'll be more time to talk about this.
I'll be back, Senna. You see, I want us to appreciate the kind of thing Gyakye Quayson faced. The kind of thing that he faced. But more importantly, can you just give me 4 minutes? Let me just draw your attention to something crucial.
Okay.
You see, the Supreme Court had earlier in a case we popularly call Amasawa decision, that when you allege foreign law, you must lead evidence to that foreign law. And the Supreme Court reasoning is that the Evidence Act says foreign law is a question of fact. In the instance of Gyakye Quayson, where are they saying he owes allegiance to?
Canada.
Correct. So if you want to make a determination as to whether he owes allegiance to Canada, which law should we be looking at?
Canadian law, of course.
So if Canadian law is a question of fact, how was that fact proved before the Supreme Court? Sana? How was that factual matter about Canadian law on allegiance proved? Who led that evidence?
But was that not supposed to have been part of the trial that happened at the High Court?
No. Remember that the High Court judge already has said that he and the Supreme Court, they have nothing in common. I just read it to you.
Yes, I understand that part.
Good. So what happened at the Supreme Court was an entirely new, originated by a writ. So I am asking you, Senna, how was this question of fact about Canadian law proved? Let me give you the reverse. I did the Jomoro parliamentary election, correct?
Yeah.
I pleaded that as far as Ivorian laws were concerned, him to be an Ivorian citizen at the time she filed her nomination. You know what the judge did? The judge set it down for trial and said, since you have raised an issue of Ivorian law, I need a trial to me. What did I do? I had to go to Ivory Coast myself, spend 3 days there, brought an Ivorian lawyer. I brought an Ivorian lawyer who then came to Ghana, appeared before the court, took an oath, was subjected to cross-examination, rigorous cross-examination by the lawyers for the petitioner. At the end, the judge said, against the MP for Jomoro, you had to prove to me that as far as Ivorian law is concerned, she's an Ivorian.
Okay.
The respondent brought an expert witness, a lawyer 15 years standing at the bar, who had come and examined him, where he testified that Ivorian law, not an Ivorian at the time she filed her nomination. That is how come the High Court judge ruled and dismissed the petition in the Jomoro matter. You see what he did? From the High Court in Cape Coast to the Supreme Court, how was the Canadian law on renunciation, the Canadian law on, what shall I say, allegiance or citizenship, how was it proved? So now.
Well, on that note, let's end it here. Thank you. Thank you. Thank you. Lawyer Godwin Edudzi Tamakloe raising some, in fact, this is going back to the history